The House Judiciary Committee will come to order. I apologize for the delay, folks. Our committee is plagued with family emergencies, car emergencies, and construction this morning. So please forgive our late start. Madam Clerk, will you please take the roll?
Chair Breen.
Present.
Representatives Edwards. Carter.
Present.
Hope. Here. Arbit. Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. I will take a motion from Representative Carter to approve and adopt the minutes from our previous meeting. Those minutes are now adopted. Today, we are going to be taking testimony on the Judicial Protection Act, HB 5724, and we may or may not vote it out. After we have testimony, we're going to go briefly at ease to discuss. We are also going to be voting out House Bill 5110, Representative Wozniak's riveting Unitrust Act bill. And I'd like to start with that. Let's see here. Voting out 5110. Do we have any cards? We have a sub for that. We also have the Department of Attorney General's neutral on HB 5110. And I will take a motion from Representative Hope to report HB 5110 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards. Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. House Bill 5110 is reported with recommendation.
Thank you very much. We are now going to move to the Judicial Protection Act. I'm going to make some brief remarks here rather than going down there. This will implement the federal Daniel Andrel Act at the state level. It will extend security protections outlined in the federal act to Michigan state court judges. So the state law that we hope to implement will mirror the federal law. The Judicial Protection Act, the JPA, will permit a judge to request that a public body or private person not publicly post the personal information of a judge or a judge's immediate family member. Personal identifying information or covered information means the date of birth, permanent residential address, Social Security number, driver's license information, tax ID number, credit card information, any other unique identifying factors. We are going to be asking SCAO to develop a form that the judge may use to make a request of a public body or a person. The judge may also delegate authority to SCAO to make such requests on their behalf. A public body that receives a request shall not post, display, or provide covered information. If the information has already been publicly posted, it must be removed within 5 business days. The act does not require the public body to delete covered information that is not accessible to the public. So the reason for this and the impediments for this bill is that our judges are in a very unique position. And we have somebody that's going to be testifying via Zoom about a horrific thing that I would not wish upon anyone. Judge Salas had her son brutally murdered right in front of her. Her husband was shot. He survived because a person who had previously been engaged in her courtroom was unhappy with the outcome. And I want to say this first and foremost, that it is absolutely, positively unacceptable for anybody to stalk or harass anyone, but especially a judge, under any circumstances because you are unhappy with a decision or for any other reason. Judges deserve to be able to feel safe in their own homes. And we are going to be taking testimony from several of our elected judges, some appointed judges at various levels. We also have some other people on Zoom that wish to testify. For anybody else that wishes to make remarks in front of this committee, I want to say very firmly that testimony needs to be limited to the bill. This has nothing to do with any particular decisions that have been rendered by judges. If people wish to testify about their discomfort or their unhappiness with a particular judge's decision, this is not the place for that. This is to talk about our judges and keeping them safe. So I just wanted to put that out there on the record because I do believe there are some people that wish to, instead of discussing why we need the Judicial Protection Act, talk about why they would prefer that judge's information be public, which is concerning. So with that, we're going to get started with Judge David McKeague. Sir, please come up. I believe you're going to also be introducing our next person that will be testifying.
Good morning. Chair.
Sir, if you could hit your red button.
Let me start over. Thank you for the opportunity to speak today on behalf of House Bill 5724. I'm here on behalf of federal judges. I suspect it's unusual for two federal judges to testify about state legislation, but Judge Salas, who'll be testifying remotely, and I both thought that it was important that we provide the background and the context for this important legislation. I'm a senior circuit judge with the United States Court of Appeals for the Sixth Circuit. My courtroom is in Cincinnati, but my resident chambers is here in Lansing in the Federal Building right across the street from the Capitol. I've been involved in judicial security at the national level since 2005, most recently as chair of the Judicial Conference Security Committee from 2018 to 2021. I remember Sunday, July 19, 2020, like it was yesterday. I received a call Sunday evening from the administrative office that a person pretending to be a Federal Express delivery driver rang the doorbell of District Judge Esther Salas and fatally shot her only son, Daniel, when he answered the door of her home in New Jersey, and severely wounded her husband, Mark Androl, who was standing behind Daniel. As you noted, Chair, the shooter was a disgruntled attorney who had obtained Judge Salas's home address from the internet and had a detailed dossier of her and the many places he could find her outside the courtroom, all of which he had obtained from the internet. Historically, in our case, judicial security is provided by the United States Marshal Service, and we have historically also largely been content to be reactive. With this tragedy, however, everything changed, and the need to become proactive to protect federal judges and their families became clear. At the top of the list of 8 changes that we sought in Congress was federal legislation to limit access to federal judges' personal identifying information, which we refer to as PII. This became the Daniel Androl Security and Privacy Act of 2021, which requires data brokers to restrict public access to judges and their families' PII. The federal legislation received overwhelming bipartisan support, passing the House 350 to 80 and the Senate 83 to 11 in December of 2022. The federal legislation does not, however, include state databases where most PII resides or include state judges. House Bill 5724 you're considering today simply implements the Androl Act in Michigan and extends protection to state judges. Throughout this process, Judge Salas has been tireless in advocating for increases in judicial security at both the federal and the state level. I'm pleased to introduce Judge Esther Salas to the committee and have asked her to discuss the tragedy that occurred in her life because of the readily accessible personal information on the internet, which is available for anyone to see. Judge Salas?
Thank you, Judge. Judge Salas?
Can you hear me?
We can. Thank you for joining us today.
Good morning, and thank you, Judge McKeague. Before I begin my testimony, I'd like to thank the Michigan Legislature, the House Judiciary Chair, and all the members of the Judiciary Committee for this opportunity to testify this morning. Despite the passage of time since the murder of our only child, Daniel, I can honestly say that the pain and agony that Mark and I feel on a daily basis, it can't be described with mere words. I don't want to take too much time, but I do want to add a little bit to the scene that Judge McKee just painted for you all. It was a Sunday, and you know, we had just celebrated Danny's 20th birthday. We had his friends over from Catholic University. You know, all of them had left by then, and we were home. We were in the basement talking, Danny and I, as we almost always did, deeply, and he was sharing with me his concerns. And I remember, you know, his dad came down the stairs, and you know, dad had always been, you know, his bro, his friend, you know, the guy he played his games and sports with, but I was his confidant, and he was sharing with me some personal feelings, and he gave dad a look like, don't bother us, mom and I are talking. And so Mark went right back up the stairs, and just as he did that, Daniel turned around. He was swinging a wiffle ball bat, and he just said, Mom, keep talking to me. I love talking to you. And just as he said that to me, the doorbell rang, and Daniel's face changed from serene and calm to just alert, and said, who's that? And before I could say anything to him, before I could stop him, he just bolted up those stairs to meet his fate. As Judge McKee noted, you know, the lawyer who was upset with me because I wasn't moving his case fast enough came to our house on a Sunday afternoon at 5 o'clock and rang our doorbell and changed my life forever. He shot my son point blank in the chest. Daniel fell back, and Mark, trying to get at the shooter, was shot 3 times, and 5 different parts of his body were shot. It's a miracle Mark survived his life-threatening injuries, but thank God he did. But you know, we now deal with different injuries, and that, of course, is the injuries of our heart and our souls. Because Daniel didn't make it. And so we endeavor to move on. Well, let me say it another way. We endeavor to move forward, never on. And, you know, we move forward after our tragedy, knowing that Daniel didn't sacrifice his life so we would squander ours on earth. So we have made it a commitment, Mark and I, to ensure that Daniel's life and his death will not be in vain. Together, we must ensure that all judges are free to do their jobs without fear of retribution, reprisal, or death, as was the case in Daniel's murder, but also the case in the assassinations of retired Judge Romer in Wisconsin and tragically Judge Wilkinson last year in Maryland. There were no warning signs that went off to alert us of danger. When it comes to evil that lurks in the shadows, there is little that we can do defensively. We must be proactive in confronting the challenges that face all judicial officers. We must guard and protect the very information that those wishing to do us harm will use as ammunition to attack us. We need to make it harder. We need to make it harder for the people that want to take this information to harass us, to intimidate us, and yes, to kill us. Protecting judges' PII and sealing that information will inevitably help to ensure that your judges are safer. As I testify here today this morning, open source information remains readily accessible on the internet, especially in the states that have no laws protecting their judicial officers. Realistically, as the citizens of New Jersey and Wisconsin and Maryland know painfully too well, failure to protect your judges will lead to other tragedies. There are over 30,000 judicial officers that proudly serve their state and local courts all across the United States and its territories. These judges are vulnerable. And we've seen judges attacked in Nevada, Colorado, Texas, Ohio, Mississippi, Rhode Island, New York, California, Kentucky, Michigan, Wyoming, Idaho, and Indiana. In recent testimony before the U.S. Congress, Chief Justice Fader of Maryland is quoted as saying, "While judges have always lived with a certain level of risk, we have never experienced risk on the scale that we are currently seeing today." Chief Justice Fader went on in that same hearing to stress that we are facing an entirely new threat environment that drives to the very heart of the rule of law and the fair administration of justice under the law. I couldn't agree more with Chief Justice Fader. Protecting individuals' lives is critically important. I truly believe that we are at another crossroads, though, when it comes to our country's democracy. By enacting House Bill number 5724, you can protect the judiciary and ultimately our democracy. Historically, violence against the judiciary has been closely tied to the toppling of democracies all throughout the world. We need only look at Nazi Germany, Turkey, Venezuela, Hungary, and now, yes, the United States, where there is no doubt a movement to intimidate our judicial officers. In our country and our constitutional system, it hinges on an independent judiciary. Judges stand at the front line, ready to protect democracy and the rule of law. The integrity of the judicial system mandates that we stand united to protect our country's democracy. We can't just sit back and allow these anti-democratic efforts to go unchallenged. No, we cannot. We need to send a strong and decisive message to those wishing to harm judges and jeopardize the rule of law that in America, we protect our judges. This is a matter of life or death. The life of our country as we know it is in serious jeopardy. As I end my remarks this morning, I would like to respectfully urge Michigan to join the growing number of states that have recently enacted laws to protect the judiciary. Those states include, but are not limited to, New Jersey, Iowa, Wisconsin, New York, and now Maryland. With your help, we can ensure that all judges at the federal, state, and local levels feel safer, that those judges feel supported, and that the system that we love so much is sound. Ladies and gentlemen, I want to thank you for this opportunity, and God bless you all.
Judge, thank you for your testimony. I cannot express my condolences enough for the loss of your child. Is that his portrait behind you?
It is. Mm-hmm. I say now he is with me literally and figuratively 24 days, 7 days a week. And it is my most precious item that I own on earth.
Thank you for being with us today. And I think your remarks only go to enhance my own opinion in that for anybody who wishes for a judicial officer's information to be exposed for the purposes of harassment or intimidation, that only underscores our need to enact this particular piece of legislation. So thank you for your testimony today.
Thank you.
Okay. Judge McKeague, thank you for joining us. Do you have anything else to add?
I don't. Thank you,
Okay.
Chair. I appreciate it.
I'm sorry, do we have any questions for Judge McKeague? No? Okay. Thank you. Next up, all at once, but talking one at a time, I'd like to invite our Chief Justice, Elizabeth Clement from the Supreme Court, as well as Judge Brock Swartzel from the Michigan Court of Appeals, and Chief Judge of the Michigan Court of Claims, as well as Judge Kathleen McCarthy of the Wayne County Circuit Court. Thank you, Your Honors.
Thank you. Good morning. Thank you, Chair Breen, Vice Chair Fink, and members of the Judiciary Committee for the invitation to speak to the committee about a subject of incredible importance, protecting the safety of Michigan trial court judges and their families. Thank you as well to the more than 30 bipartisan members of the Michigan House who have sponsored the Judicial Protection Act. The Judiciary is also appreciative of the support from your colleagues who have supported similar legislation in the Michigan Senate. Here is the key question I want to address for the committee today. Why is protecting Michigan judges so important? As if you need to hear that from me after hearing from Judge Salas, but I want to give you our perspective from Michigan. In today's volatile political climate of increasing threats and attempts to harm all public officials, judges are no exception. By the very nature of their work, judges are called upon to interact directly with a wide array of individuals, some of whom are likely to be dissatisfied with the outcome of their cases. This direct interaction with litigants results in increased risks to the personal safety of judges and their families, especially the judges that serve the local communities you represent. Clearly, we do not want any judge or their family member to endure what happened to Judge Salas's family or Judge Julie Kosurik of Travis County, Texas. In 2015, an angry litigant waited outside her home and shot her over and over again. To get back on her feet, Judge Kosurik underwent dozens of surgeries and laid in a hospital bed for more than a month. Consider the tragedy of Maryland Judge Andrew Wilkinson, who was gunned down, murdered in his driveway, not long after awarding custody of the suspect's children to their mother. Here are just a few recent examples of threats right here at home in Michigan. A prison inmate from White Lake threatened to kill an Ingham County judge. A Rochester Hills man charged with assault with a deadly weapon threatened to shoot an Oakland County judge. A Georgia man upset about an election-related decision threatened a Court of Claims judge. But while we do not want any Michigan judge or their family to face that unimaginable pain and suffering, what we must remember is the potential impact of these threats on the rule of law. Our democracy depends on a judiciary and a bench that makes decisions without fear of violence. As a co-equal branch of government, judges have an obligation to be fair, to be independent, and to make decisions based on the law and facts presented to them in court. We owe this to the people we serve. At the same time, the judiciary is owed every effort to protect them from threats and from violence, not just against them personally, but also their families. That is a burden my colleagues on the bench cannot bear and should not bear as they make critically important decisions. What is quite worrisome to me is that such threats are on the rise. While we don't have state-level statistics, we do know that threats and inappropriate communications against the federal judiciary have significantly increased in recent years. For example, in 2015, the U.S. Marshal Service reported 926 threats and inappropriate communication against federal judges, prosecutors, and court officials. In 2021, that figure rose to over 4,500, an increase of almost 490%. In combating this trend, the federal government and many states are providing protection for judges' personal identifiable information. This is exactly what the Judicial Protection Act is designed to do: prevent the publication of personal identifying information that could potentially put judges and their families at risk. Think about the cases judges in our district, probate, and circuit courts hear day in and day out. And think about what happens in their courtrooms, as their decisions often make a huge impact on the lives of the people in front of them. It might even be the most important day of their lives. We have no way of knowing where the next threat may come from, or the next assault, or the next attempt to seek revenge for an unfavorable decision. But we can take steps to protect Michigan judges by keeping their personal information away from those who would do them harm. Thank you for supporting the Judicial Protection Act. By standing up to protect Michigan's judiciary, you are safeguarding the rule of law. I'd like to turn it over to Court of Appeals Judge Brock Swartzel.
Thank you. Thank you, Chair Breen and Vice Chair Fink, for the opportunity to speak today in support of House Bill 5724. I am here on behalf of the Michigan Judges Association, which represents the interests of the state's circuit court judges and Court of Appeals judges. I'll be brief, and I'm not going to repeat much of what has already been said today. If there is one principle that every judge I know agrees with, regardless of judicial philosophy, it is this: we must decide cases and controversies without fear or favor. As you've heard today, there has been a dramatic increase in threats to the judiciary over the last decade or so. I echo what has been written by Chief Judge Hala Jarbo of the U.S. District Court for the Western District of Michigan and Chief Judge Sean Cox of the U.S. District Court for the Eastern District of Michigan, who wrote to this committee recently, quote, "For the security and safety of our judicial branch, we strongly encourage passage of House Bill 5724, close quote. In short, we need the legislature's help to keep judges safe. Federal courts, and even more so state courts, do not have the budget resources or the legal authority to station a marshal or a court security officer at every judge's residence at all times. House Bill 5724 is not the full solution, but it would be a critical tool in the judicial security toolbox. The bill, as you've heard earlier today, is modeled after and would implement protections found in the federal Daniel Anderl Judicial Security and Privacy Act of 2022. Broadly speaking, the bill would prohibit the publication of certain personal identifying information about a judge or someone in the judge's household. 37 other states are considering or have already enacted similar legislation. States that have already enacted their own versions of the Daniel Anderl Act include such diverse areas of this country as Florida, Maryland, New Jersey, Pennsylvania, Ohio, Illinois, and Texas. Some of these states have in fact provided very broad, extensive provisions in their laws. Michigan's House Bill 5724, however, is more narrowly tailored to suit the specific needs of Michigan. This bill is closely modeled on the federal Daniel Anderl Act, though the bill is narrower than its federal and state counterparts in several ways. For example, the bill is focused solely on the judiciary, unlike some other states. The scope of those covered is not intended to extend beyond a judge's household, unlike in some other states and at the federal level. And there is no criminal penalty in this bill. Moreover, with respect to information protected from disclosure, the bill provides several exceptions that will permit the publication or verification of certain information about a judge, including the city and township of a judge's residence, a judge's date of birth for purposes of our Constitution's age requirement, protected information that is voluntarily disclosed, and information on a matter of public concern. As the bill goes through the legislative process, we understand that stakeholders may have questions about the scope and implementation of the bill's provisions. On behalf of the judges with whom I have worked with, I can commit to you that we will work collaboratively to develop and implement reasonable solutions. I welcome any questions that you may have today or as the legislative process unfolds. Thank you very much.
Good morning. I am Kathleen McCarthy, and I'm here from Wayne County Circuit Court along with my colleague Martha Snow. I'd like to thank the committee for hearing some testimony today and, of course, the co-sponsors of this important bill. I was asked to speak on behalf of the state court judges because I am the longest-serving family court judge in the state of Michigan to date. Until I left the family division 3 years ago. I served 20 years in the family court and a total of 23 years as a state court judge. And I was asked to relay a couple stories that are personal and happened to me as a court judge, and also, with our family court judges, to explain that very few judges would ever serve in the family division for 20 years, not only because of burnout of the types of cases that we hear, deciding custody, parenting time, child support, but very seriously the amount of threats that we receive from making these decisions, not only to myself, but to my family and my children. I was assigned a family court case, probably it's now about maybe 15, 17 years ago, that involved a gentleman, I use that term loosely, that had been recently released from prison he was in prison because he had murdered a couple individuals that didn't pay their drug debts. You would have thought he would have been in prison for life, but based on a technicality that I don't need to get into, after 7 years of serving prison, he was released. And he hooked up with a young lady, 20 years his junior, who was very enthralled with his amount of money, the fancy cars, the nice clothes, etc., that went with that lifestyle. And she had 2 children with him. That case came to me as a family court judge on an emergency petition for temporary custody. She presented to my court with her lawyer, and she had a black eye. And I had a police report of what had occurred, and that was that a neighbor, I lived in the same community as this family, a neighbor had seen this man dragging her across the parking lot of our church by her hair. And when he was arrested, he had all of her identification in his pocket, her driver's license, her passport. She is a Canadian citizen. We live in the Detroit area right across the border. And because he had all of her personal identifying information, she could not escape. First of all, the house that they lived in had cameras all around it. So he was aware of what she was doing 24 hours, 24/7. And this day, she got up the courage to try to escape. She went and fled to our church, which was right around their corner, and then he saw her leaving the house, and he pursued her, and she was beaten. He was subsequently arrested, and that case never prosecuted from a domestic violence standpoint, but I got the custody case. So it started with me giving temporary custody to her and allowing her to travel safely back to Canada. And then that's when my life turned to hell. It began first with various individuals that I thought were my colleagues or lawyers that I had interacted with being called to represent him because he had found out and discovered, who were my close friends to represent him to gain an advantage in my courthouse. When that didn't work, he then he hired a couple rather vicious family law attorneys to represent him, and then began the motions to recuse me from his case that weren't successful as they had no basis. Then it involved I had 2 young children at the time. They were about maybe 7 or 8 years old, and we all went to the same church, and my children went to the same private school that their children went to. And it involved me attending church on Sundays. And when I would turn around to shake hands for the peace offering at church, the entire 16 members of their family would be lined up behind me at church as a point to make sure that I knew that they were there, who they were, and that they were going to intimidate me. It also involved almost being run over in the parking lot of that church, dropping my children off to school one day. Beyond that, it continued with the case of me appearing then at public events, and various family members would appear at each of these events. There was never a specific direct threat necessarily, but family members would literally stand behind me as I was going to talk to someone at the event. And these are very large gentlemen. And they wouldn't touch me. There wouldn't be enough to arrest them. It wouldn't be enough for me to get a PPO. It was just enough to constantly have this threat of intimidation for his case. Then it began and ended with, unfortunately, colleagues of mine. This particular family owned a lot of restaurants in the area, and they hosted fundraisers for our state Supreme Court justices, judges of the Court of Appeals, judges of the state court. And so you can imagine other state judges or any judge, you know, on a salary that is running for reelection and someone's offering to host a fundraiser at their restaurant and pay for it. So these people had a lot of favor. The last thing that happened was going to a fundraiser at a appellate court judge's house, and they offered to host the food there, and then showed up with a lot of family members, knowing that not only that I was there, but that one of the lawyers on the case was there, but also that one of the appeals that they had filed to try to undo my custody ruling was held at that house. Eventually, I was up for election. They hired picketers to stand outside of my courthouse to try to get me to not prevail at my current election. But one of the other things they did was gathered all of my personal documentation from online. My house address, my house up north address, all of my children's information. I had gone through a divorce. They had not only culled my divorce records, anything personal in there. They had subpoenaed, judges have to fill out a form every year if they've been given anything over $350 in value. They did a FOIA request to gain all of that information. They took all of my personal information, hired a company to put together not only a website, but to push out a message that went to every Wayne, Oakland, and Macomb County judge with this tortured web information that none of it was all half accurate. None of it was actually accurate, making me appear to be less than favorable. And of course, to intimidate me, harass me, and embarrass me, which it certainly did. Eventually on that case, I had a custody trial, and a doctor from Canada, and as well as domestic violence individuals that treated her, a doctor from Canada testified that it was the worst domestic violence he had ever seen. During a sexual experience, he had bit off a piece of her labia. When he testified to that at my custody trial, he said it was because she liked rough sex. This is the kind of individual I was dealing with. It culminated after this website went out, and this intimidation did not stop. I did get a visit from the FBI because he had threatened to kill 2 FBI informants. So they came to my courtroom to tell me that this was a very real situation for me, and I needed to protect myself and my family. So real for me that I actually moved from my house, which was on a main street in town, to another location in an effort to protect myself. That was one situation. This is not personal to me that these situations happen. I was a presiding judge of the family court for 8 years. These are conversations I have with my colleagues on a daily basis, talking about how sovereign citizens file UCC statements against us, against our property. We have to have lawyers in our court represent us to remove these filings against us. Websites that get created about our personal information and then are put online, and we get death threats. I had another situation with another gentleman who had been in prison, and it was a simple child support case and a set aside of a paternity. And when he got released from custody, he went to our front of the court, and we explained, here's the paperwork that you need to fill out to take care of this situation. He didn't take care of it till about 8 years later, until the child had turned 18. And then he moved to set aside, and based on the law, I could not grant this request. That case got public information. It got news worthy, so much so that it made it to the Jay Leno show, and he made a joke about it. From that situation, when he made that joke about it, my courtroom was inundated with serious, graphic death threats. I was going to be raped. My children were going to be raped. This went on so profusely that we could not answer our court phone. for about a month. These were such significant threats that they were telling to my court clerk or leaving with no concern on my recording system at my court. Now, eventually, our sheriffs were able to intercede with some of these and call the people and say, hey, you know, stop threatening us. But we don't have any laws that would apply, that would be a crime in the state of Michigan. And so I thank you for your time. This is an incredible first step to getting our personal information offline. But I really ask that we go further in the future, after step one, that this become a crime to intimidate us as state court judges or any judge, both state and federal, because as Judge Salas said, as our Chief Justice just said, this is a threat to our Constitution. It's a threat to our democracy. These threats are intended to change my opinion, to make me do something that I otherwise wouldn't do, to recuse myself from cases because I can't handle the threats. That's why this is so important. Thank you for your time.
Thank you to all of you. I am a lawyer myself. I never appeared before any of you. I probably won't in that aspect, but I worked for the Free Legal Aid Clinic out of Wayne State, and we handled family law cases. And when you are dealing in cases involving people's children, that is one of the most emotional type of cases a judge could handle. People have very heightened reactions, understandably. So thank you all for your service and for sharing these very personal experiences. I appreciate especially, Judge Schwartzler, what you said about the bill being narrowly tailored. This is simply to shield your personal information. So I guess I do have one question here is, can any of you think of a legit reason for the general public to have access to your personal information as to where you live or where your spouse works or where your children go to school? Can anybody think of a legit reason for that information to be available to the general public?
I've thought about this as, I think I got involved in this project last summer. And as I've gone through it, I can't think of a legitimate reason. Now there are, for election purposes, there's good reasons to know where the city or the township of where a judge might live. My age is an issue because under Michigan's Constitution, we can't run for election if we're 70 or older. But that's why this bill was written in that way. It's narrowly tailored specifically for Michigan. This bill might not work in Wisconsin or California or some other state. It's designed to fit in to work in Michigan. I hope that answers your question.
I can't think of any reason.
Okay. Thank you very, very much for your testimony. And I appreciate your commitment also to keep working on the bill. Oh, I'm sorry. Representative Fink, you have a question?
Just, thank you. Thanks for your testimony. My question is essentially about how well it works. I understand that Michigan would not be the first state to adopt legislation along these lines. I appreciate, Judge Schwartzel, you pointing out that this is written for our contexts, including the issues that you just mentioned. But how effective is this? It's, for instance, much of Judge McCarthy's testimony wouldn't be affected by this, by this legislation. Much of the background that she gave us wouldn't seem to be affected by this. So, how effective do you think that this actually is?
I think it's, as I mentioned in my testimony, it's a tool in the toolbox. It's not the full solution. Security cameras, dogs, firearms, all of the above may be necessary to protect someone's home. This is one tool in the toolbox. It's not the full solution. But with that said, some of these crimes that we've seen, some of these murders that we've seen across the country, they might have been averted if there was a cooling off period. We have cell phones, we have smartphones that make it instantly accessible to someone to get an address. And they can go in that heat of passion and do something horrific. In years past or in a prior era, there might have been a cooling off period, and that person might not have gone through with that horrific act. So we're in a different era. We need different tools. That's what this is.
Thank you, and I guess I didn't think about this until you were answering, but in contradistinction to Chair Breen, I've appeared in front of two of you, so I appreciate the work that all of you are doing, in our judiciary, and I do appreciate your testimony today. Thank you.
Thank you, Your Honors. I'd like to now call up, we have Dan Quick from the State Bar of Michigan. Is he on Zoom, I believe?
Yes, can you hear me okay?
Yes, thank you, sir.
Thank you. Chair Breen, thank you very much for having me here. My name is Dan Quick. I am a trial lawyer with Dickinson Wright, but I am also currently the president of the 46,000 member State Bar of Michigan. And in that capacity, I am honored to testify in support of House Bill 5724. As many of you know, lawyers are bound by a strict code of ethics. The preamble to those rules states, in part, that as a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by the legal profession. Nothing is more core to our justice system than the rule of law. It teaches that all are equal before the law and that the law is carried out through the justice system, not on the street. This is a foundational principle of our democracy. Our judicial officers may not always get their cases or their decisions right. That's why we have appeals and elections. But none of them ever deserve to have their life, liberty, or privacy threatened. And certainly their direct family members do not deserve to be threatened or harassed. One of the core efforts of the bar is to work on civics and civility throughout our state, from elementary schools to senior centers. We do that, and our oath requires it, because our democracy relies upon the support of our citizens of our judicial system. Too few of those citizens have even a basic knowledge of civics and history. That in turn erodes the stability of our system. So this bill is important protection for judges and families, as several judges have testified so eloquently, but it also is a strong modeling for our citizens that in these times, nonpartisan principles of democracy are greater than any potential political issue. And I was heartened by analogy to see that when the federal bill was before the Senate, the United States, that it passed 83-11. As has been noted, this is a more modest bill than that in several ways. But to the representative's question, I think this is not entirely about whether this is the complete solution to the problem. It is in part a signaling to our citizens about the importance of these institutions. So as with Judge Schwartzel and the others, if there are questions going forward, certainly the bar is here to work as a partner with you with regard to this bill and with various stakeholders who are all strongly supporting it. Thank you very much.
Thank you. Any questions? Okay. Thank you very much for your testimony. We do have two other people wishing to testify in person. We have multiple people on Zoom, and given time constraints, we may or may not be able to get to any of them. For now, I would like to call up Katie Albasta Kelly and Karen Hand from the Michigan Association of Registers of Deeds. And please come forward. I'm going to ask that you try to be as brief as possible, noting that we do have a commitment to keep working on these bills as best possible.
Yes,
Thank you.
Thank you, Madam Chair, and the rest of the Judiciary Committee. We will keep it brief. My name is Katie Albasta Kelly. I'm the Register of Deeds in Saginaw County. I'm here on behalf of the Michigan Association of Registers of Deeds as their current president. In regards to House Bill 5724, the Register of Deeds asked the committee for considerations on the following items, things that the bill may not include, or some things that in practicality, when this does get implemented, if it gets implemented, that we'll be able to fulfill this in a way. The request to shield and redact information. The Register of Deeds office must be provided with a LIBOR page or unique identifying number to identify which documents to protect. Without this information, how will we know if we have the correct documents or individual for that matter? My name's Katie Kelly, and in my repository of almost 7 million documents, we want to make sure that we have the right Katie Kelly, right? Or whoever that individual may be. We want to get this right. We need to get this right. And if the information is fed to us in that way, we'll be able to comply with the law. There has also not been an expiration or unshielding talked about. If that were to sunset in some way, it would be imperative that we know how to implement that into our systems at the Register of Deeds offices. An implementation period would also be something that would help us comply with the law in a way that, some states have gone up to 16 months for an implementation period to make sure that our software systems and our repositories are going to react in a way that will allow us to comply with the law. And last but not least, please consider the definitions of redaction versus shielding. We will have the abilities in our systems to either, it's an electronic whiteout method, or to entirely shield the document from public view. So just something to consider along the way will also be imperative for us in the technology in which our offices have. At this point, we put in a neutral standpoint for this bill. We want to get to a support, and we're confident that working with the stakeholders that we'll get there. And thank you for your time.
Thank you very much. Do you have anything to add? Okay, we appreciate that. We've been speaking with your stakeholder
Yes.
representative, and we have some very specific things that I think will help us get to a very, very good place on this bill.
Wonderful. I'll look forward to it.
Okay.
Thank you.
Thank you so much. Wait, we have a question.
Yes.
Representative Wozniak.
Thank you, Chair. In your office then, would you go ahead and redact or whatever you would do to the document on your own, or would your office have to receive the request?
We would prefer to receive a request, and that would allow us to shield or redact specific documents. Our repository goes back to 1835. If there's a Katie Kelly that had a property in 1900, we probably don't need to shield that specific document unless it's been a family home that stays. So the repositories are so large, and Saginaw County is a mid-sized county, but I imagine in Wayne County, Macomb County, that millions and millions and millions of images that exist, we would want to be told specifically what to protect, and we want to get that right.
Right, you wouldn't go forward on your own.
Correct. We would prefer not to do that.
Thank you.
Thank you. Yes.
Thank you very much for your testimony.
Yes, thank you.
Okay. We are now going to turn to some folks on Zoom, and for anybody who has submitted written testimony, please note that that will be included in the minutes. Your written testimony is preferable, if possible, to oral testimony, because it will allow us to hear some of the people that have not submitted anything. Given the time constraints we have, I'm going to ask that if I'm able to get to you on Zoom, please limit your remarks to no more than 2 minutes. Shannon Tanis, are you available?
Hello.
Yes.
Yes. I would like to speak on the fact of the oversight that I've been doing regarding the judicial branch and bar members and the corporation fraud that they have been committing, and also using their bar license to hide sex offenders in nursing homes and other mechanisms. This bill allows them to continue to do those egregious frauds and harms upon the people. The people have the right to have access to public information to investigate. I'm very sorry for the people that have been harmed by these issues, but we have laws already in place that can be used to hold these people accountable. The judiciary has our law enforcement at their beck and call. They have our judicial branch at their beck and call, and they could utilize that with what is already established. I don't understand how the judicial branch thinks that they can abuse their power and that the people are not going to hold them accountable. and that they can incite our legislators to create more legislation to give them private authority. It is the utmost importance of our republic for the people to be the highest authority over their branches of government. So this bill speaks volumes that the judicial branch are using their bar associations and their bar cards to incite more privilege above the people, and that they're abusing their powers with the mechanisms that are already in place. So I oppose this very wholeheartedly. I do agree that there are some national security type of issues regarding certain protected information, but the fact of the matter is U.S. Marshals don't even have a mechanism to report if there's fraudulent people that are impersonating their own agents. If they can't even oversight that mechanism, why are we creating more authority that incites what they should be doing already for security issues?
Thank you for your testimony. Please note that this bill is to protect judges' personal information from the general public so that they cannot be harassed or intimidated in their own homes. We will definitely consider your comments. Thank you. I will now like to call on Tom Howe.
Thank you to the committee here today. A lot of the issues here we have in Michigan is we're known across the nation as some of the most corrupt courts, and we're having a problem here. We're trying to give the judges more immunity at this point, but there's zero mechanism that's actually functional in Michigan to correct these courts. Right now we have a de facto probate court, which is in violation of Article 1, Section 10, which is the EPIC code, which is MCL 600.681.
Mr. Howe, I'm sorry. This is about the Judicial Protection Act and not any other area of law. Is there any reason why you would need a judge's personal information for what you're discussing?
This is why a lot of these things are happening here in Michigan, and we need the mechanism here to put some pressure on people that they need to act de jure. They need to, and a lot of these de facto courts need to be ended. And having a bill like this come forward when we have multiple problems in Michigan that need to be corrected by this committee and the Senate committee first is quite alarming to the residents who domicile here in Michigan. And so I'd like you to end this bill. I'd like you to work on actual real bills that will help the state of Michigan and the people who domicile here and correct all these corrupt laws that have been on the books for about 46 years.
Can you tell me, sir, why you think having access to judges' personal information will help with that?
Yeah, well, this personal information, I believe, should be on the record. They took the job, and it needs to be out there. And if they're going to act de jure and they're going to be honest and fair and allow everybody their constitutional rights, there shouldn't ever be a problem with anything they do.
All right.
And
Thank
a lot of this stuff we have.
Mr. Howe, I'm so sorry. You went over your time. I'm sorry. We appreciate your comments. If you wish to submit written testimony, I encourage you to do so. The committee will now go at ease. back on the record. Unfortunately, we are short of time today. And so for the people that are still on Zoom, I would encourage them to submit written testimony. We will be taking additional action on this bill at our next hearing. I'm going to read in some cards. We have James Ryan from Michigan Probate Judges Association supporting the bill, not wishing to speak. Stephanie Johnson from the Family Law Section of the State Bar of Michigan supporting the bill, not wishing to speak. Monica Martinez from the Michigan Judges Association supporting the bill, not wishing to speak. Judge Martha Snow supporting the bill, not wishing to speak. Judge Mike Carpenter, President of the Michigan District Judges Association, supporting the bill, not wishing to speak. Chief Judge Hala Jarbu from the U.S. District Court, Western District of Michigan, supporting the bill, not wishing to speak. I believe written testimony has been submitted. Chief Judge Sean Cox from the U.S. District Court, Eastern District of Michigan, supporting the bill, not wishing to speak. I believe also has submitted written testimony. I will take a motion. Oh, I'm sorry, we have one more card. John Fournier from the City of Ann Arbor, supporting the bill, not wishing to speak. I will take a motion from Representative Devendorf to excuse absent members. Good. Seeing no additional business before the committee, we are adjourned.